Real estate investors and housing providers. There is an imminent threat of a real estate collapse in the state of New York if a recently resurrected piece of legislation becomes law. I'm Matthew Lyman, the host of the Landlord Advocates. Welcome. This legislation is called the Tenant Opportunity to Purchase Act, TOPA. There is going to be a big rally on February 7th in Albany, New York, from tenants being bussed in from New York City in support of TOPA, Tenant Opportunity to Purchase Act. What this is in a nutshell is it gives tenants the ability, the first position, to buy the rental property where they live that you are looking to sell. So for some of you who are looking to sell your property to a real estate investor like that, it's not going to happen. What we're going to do in our video here, as most of you know, when we share things with you, it comes from here and maybe a few notes. It can't happen this time. This legislation is 18 pages long. It has regulations and timeframes in it that are highly restrictive to those looking to sell their rental properties. To make sure that we cover the bases necessary, we are going to extrapolate and read parts of this legislation to you so that we are on par with what you need to know. Now what they look at is they give the first right to purchase to tenants. What do they define as a tenant? Somebody that's lived on the property for more than 14 days consecutively. A tenant, a subtenant, a leasing, a sublessee, those have a right, those people have a right to buy your rental property when you want to offer it to sell. The first, as we have said, is a tenant. The second is what they call a qualified purchaser. And we'll go over what they mean by a qualified purchaser momentarily. The third is a third-party investor, a third-party buyer. Basically an investor, someone who's not a tenant and someone who is not a qualified purchaser. There are exemptions to this act. One is properties owned by the municipal, state, or federal governments. How convenient that they're going to impose laws upon you, but not on themselves. Pretty convenient. Another one is single unit properties that are not owned by a corporation or an LLC. So some of you have your properties under an LLC to protect you from lawsuits and litigation, and they can only go after that corporation or that LLC. You are not protected. There are other aspects of people who are protected entities that are protected, but we're looking at just the top ones. And the other one would be a multiple dwelling owner that has had property that has been able to be rented, multiple family, multiple whatever, January 1st, prior to January 1st, 1974, basically the last 50 years. If it's been rented out prior to that time frame or says that you're okay, that you may not be affected by this act. But of course the powers that be in the New York State Legislature may amend it to remove that aspect. So now everybody has to follow through on this and not just you. Now, they actually have in the early part of this legislation, they have what they call a voluntary election to participate. When we share with you the regulations and timeframes to get it to the point of closing on the property, you will understand fully that this program is not one that you would voluntarily want to participate in. If you do, and you are exempt, and you want to voluntarily participate, we are recommending that you go see a doctor immediately. You need help. Tenants are given the first right to purchase, and the first right of refusal. We're going to go through what that means momentarily. They are also allowed to form a tenant organization that has different factors that they must follow through, different regulations, different this, different that. We are not going to get into that, because we are not here advocating for tenants on how to form an organization that can harm you selling your property. We're not here for that. Now, what do they mean by a qualified purchaser? What they mean by that is a bona fide, not-for-profit, exempt from federal taxes. A purchaser that has demonstrated a commitment to either the democratic residential control on the rental property by which they live at, or a commitment to community engagement as evidenced by the relationship with neighborhood organizations or tenant counseling organizations. The purchaser has agreed to transfer the ownership of the rental housing accommodation to the tenants when feasible. And the purchaser has demonstrated a commitment to the provisions of affordable housing for low, very low, and extremely low income New York State residents, and to prevent the displacement of such residents. So basically, tenant advocacy organizations that have funding will be seen as a qualified purchaser. Now, they are also allowed, the tenants, to get what they call a supportive partner. And basically what the supportive partner is about all of what we said. There can be an individual or an organization, but the supportive partner is not looking to buy the property to be in position to buy the property. They're not looking to do that, but they're looking to facilitate the knowledge that you need to make this happen so that you, as a tenant, can buy the property from the landlord. When this supportive partners list is promulgated, it will be stored with the Housing and Community Renewal Office of New York State. You're going to learn a few more things about that office momentarily and what it will do to you if you don't follow through on the regulations required by this act. It's not pretty. It's not pretty. What must be done? You write a first offer. When you want to sell property, this is what you must do with the tenants. You must do the following. It's amazing. You must notify each tenant above the age of 18 by certified mail that you intend to sell the property. And it must also be posted conspicuously on the rental property of your desire to sell. The property must also be in the top 3 languages spoken in the home within the property's consensus census tract, according to the United States latest Census Bureau. So therefore, you live in a community where they are speaking French, Spanish, and English. All of this must be in French, Spanish, and English. Whether you want it to or not, this legislation says it must be. It must state that the owner intends to sell a rental housing accommodation, a statement of the rights of tenants and qualified purchasers, and the accompanying timelines described in this section. A statement that the owner shall make the related disclosures described in the section available to the tenant, and a statement that they are giving this information to the tenants that will be provided to the Housing and Community Renewal Office. You must provide all of that to them to let them know that you've done what this act provides that you must do. You also must have related disclosures to the tenants, some of which include a floor plan of the property, an itemized list of monthly operating expenses, utility consumption rates, real property taxes, and capital expenditures for each of the 2 preceding years. You have to have that on it. That's crazy. That's crazy. A list of any known defects and hazards and any related costs for repair. Have that on it. The most recent rent roll, a list of all the occupants, a list of all the vacant units, including the rate of rent for each unit, and any escalations and lease expirations. So that means now, all the tenants in these buildings, whether it be a 1 unit, 2 unit, 3, 5, 20, 50, they're now going to know the names of all the other tenants and all of them are paying rent. So if the rents differentiate, you know that they're going to complain, hey, I'm paying more than him, why? Or I'm paying more than her, why? Any mortgages or any financial commitments that you have to the property must be disclosed to the prospective tenant who wants to buy the property. They have a time to submit an interest in buying this property, a statement of interest. Tenants should have 20 days in a rental housing accommodation consisting of 1 or 2 units and 30 days in a rental housing accommodation with 3 or more units to deliver the statement of interest. Tenants in a rental housing accommodation with 30 or more units will have an additional 15 days. Now, what do they mean by a 2 unit or 1 unit? In a 1 unit, and there's a multiple household in that 1 unit. So the Hatfields and the McCoys living in a single-family home, they qualify for this. The statement of interest shall be a clear expression from the tenants that they intend to further consider making an offer to purchase the rental housing accommodation. Now they're also given 21 days more to select a supportive partner. Now, put that all together, the 1 or 2 units now is 41 days. 3 units to 29 units is 51 days. 30 units or more is 67 days, just to get to the point of submitting an offer to buy the real estate. You're at 67 days, that's just an offer to buy. Not saying I am going to buy, just saying I'm interested in buying. Now, if the multiple households want to form a tenant organization, they are given an additional 45 days to create that tenant organization, which can be a two-family, up and down. That now is a tenant organization. They have 45 more days in order to acquire a tenant organization and put forth an offer. More time, more lost time of you selling the property to a third-party investor who may offer you a lot more money than what you can possibly get from tenants or a qualified purchaser. If it's a 3-unit or more, they're given 60 days to form a tenant organization. 10 to 29 units, 90 more days to form a tenant organization. 30 units or more, they're given 120 days to deliver an offer and form a tenant organization. See how that clock is tolling, the calendar is tolling, and yet you're not able to sell the property because these people are looking to buy and it takes this long to get them to that point? Time to secure financing. Oh, here's even more time added to this process. One household, just one particular household, has 30 days to acquire financing. The lending institution, though, can extend that to 45 days. If it's 2 units or a single-family home with 2 households, that's 90 days. But the lending institution can make it 120 days. Now, with 3 units or more, it's 120 days to get financing. But, the financing institution can make that 160 days for financing. When you add up all those time frames and all those days, you're looking at months before you can even get to the point of closing, if it even gets that far. And they're at 160 days, adding on with that 45 days and 90 days and all of that, and they don't get financing, you're about that sale 7-8 months you've been holding on to the property with no sale to a third-party purchaser who may have been willing to offer you a lot more money with like a 10-day close, no concessions, cash only. You don't get that opportunity anymore, and this act becomes law. Time to close, 14 days to close. Right of first refusal. If they have a right of first refusal, the tenant has another opportunity to buy the property from you. Now before you sell this property to a third-party purchaser after the whole thing fell through, you have to now give the tenants or the qualified purchaser a second opportunity to purchase this property from you. First right of refusal. That is to add more time to that process. You have to provide a statement as to whether a purchase contract with a third-party purchaser exists for the sale of the rental housing accommodation, and if so, a copy of such purchase contract. You have to provide that to them. If you have such contract with a third-party purchaser, you have to deliver this contract within 2 days to the tenants or the qualified purchaser. If it is only one tenant, that one tenant has 10 days to accept that offer. If it is a multiple unit household, they have 45 days to accept. A qualified purchaser shall have 30 days. So now they refuse to now qualify, or you have a third party guy that wants to buy the property from you. Now they're given another 45 days to buy the property. So now here I am, I'm a third party, I'm ready to go, I'm ready to buy. But now I have to give them the first right of refusal, which will be another 45 days. There's an appraisal. They have to do an appraisal if they want to. that appraisal is in within 10 business days. And the cost of that, 2/3 of it is borne by the person selling, and 1/3 by the person looking to buy. Now, if all of this falls through and you refuse the offer by the tenants or the preferred or the qualified purchaser, now you're in a position where you have to refund them the 1/3 of the cost for the appraisal of the property. Now, it goes on further to say that if a tenant opportunity to purchase buyer buys it, a tenant or a qualified purchaser buys it, it goes on to list all of the regulations they have to follow. Well, we don't care about that. You have to deal with it. You have to buy the property now. Now you're going to get to see what it's like to be a landlord and having to deal with the same crap that many of us have had to deal with over the years in the state of New York. If this all goes through and a tenant buys or a qualified purchaser buys, you have to provide disclosures and all of that to the Housing and Community Renewal Office. That after the sale has been done, you must do this. Failure to file a declaration is called. Owner certification and disclosure. Every owner of a residential property in the state shall, within 15 days of the sale of such residential property, submit a signed declaration under penalty of perjury, affirming that the sale of such residential property complied with the requirements of this article. Now, failure to do this within 15 days can result in a penalty of up to $1,000 per day per unit for not doing this. Now, let's say you sell the property and just turn your nose up to this entire process. There is a mandatory penalty put upon you, and it goes in 3 different stages. The first time, if you do it, you have to give back to the state 10% of the purchase price of the property goes back to the state as a penalty. If you do it a second time, you have to give back 20% to the state. Doing a third time, you have to give back 30% of the purchase price to the state of New York as a penalty for you avoiding this legislation if it becomes law. Now, there's an aspect of this legislation that seals the deal and lets you know exactly where the state is on this act if it becomes law. It states, if a court finds ambiguity and there is any reasonable interpretation of this article that favors the rights of the tenant, then the court shall resolve ambiguity toward the end of strengthening the legal rights of the tenant or tenant organization to the maximum extent permissible under law. There's a lot to this legislation. It's 18 pages long, but that is it in a nutshell. It clearly states that if in court there's any ambiguity, the court will rule and side with the tenant. It clearly states that. The other thing that we bring up that this legislation does not even talk about is what if the tenant is being evicted during this process, or before this process, before they put in an offer. They're 8 months behind the rent, they're destroying the property, they're violating the lease, whatever it might be that says you want them to go bye-bye. Nothing in this legislation states that they are being evicted, that they are disqualified from participating. And at the back page of this legislation, it says the court, any ambiguity will rule in favor of the tenant. Is that an area of ambiguity that if you are evicting your tenant, all they have to do is say, I want to buy the property, and it will delay the eviction of the tenant for months to come. It is clear that this legislation, titled Senate Bill 3157, is highly detrimental to housing providers and real estate investors in the state of New York. This Tuesday, February 7th, tenants are taken to the halls of the state capitol, pushing for this legislation to become law. We must let our voices be heard and let them know, and let the legislators know, that we do not want this to become law. Because if tenants believe that the rents are high now, we can guarantee that the rents will go up even higher as more oppression is being put on the shoulders of housing providers and real estate investors across the state of New York. Landlords, stand up for your rights. Housing providers, stand up for your rights. Real estate investors, stand up for your rights. If not, there will be nothing left